But I speak to everyone when I say that the Barrett family has captured America's heart. It is highly fitting that Justice Barrett fills the seat of a true pioneer.
Did I understand you correctly to tell Justice Kagan that the government wanted to reserve its right to maybe not follow a Second Circuit precedent, say, in New York, because you might disagree with the opinion?
Our general practice is to respect those precedents, but there are circumstances when it is not a categorical practice. It is, and that is not
this administration's practice or the longstanding practice of the federal government. And I'm not talking about in the Fourth Circuit, are you going to respect a Second Circuit? I'm talking about within the Second Circuit. And can you say, is that this administration's practice or a longstanding one?
As I understand it, longstanding policy.
Oh, that's gonna hurt!
It's been a tough week for Trump, considering many of those he would bank on their support have turned on him. Take, for instance, Thursday's hearing on birthright citizenship, where it was a game of which Trump-appointed judge was going to lambast Trump's solicitor, as several of them took turns ripping into Team Trump during Thursday's hearing. Kicking things off was Supreme Court Justice Amy Coney Barrett, who was appointed by Trump back in 2020. Well, she ripped into Trump's Solicitor General on Thursday for disrespecting one of the High Court's liberal justices, quickly drawing criticism from the MAGA crowd for, daring to speak out against the cult leader or any of his minions.
On this case and on many similar cases, the appropriate way to do it is for there to be multiple lower courts considering it, the appropriate percolation that goes to the lower courts, and then ultimately this court decides the merits in a nationwide binding precedent. You have a complete inversion of that through the nationwide injunctions with the district.
So, General Sauer, are you really going to answer Justice Kagan by saying there's no way to do this expeditiously?
Well, I'll refer to my former answers. Rule 23 provides the tools to do so, multiple injunctions.
But you resisted Justice Kagan when she said, could the individual plaintiffs form a class?
That has never been briefed in the court below. I do not concede that we wouldn't oppose class certification in this particular case. There may be arguments that this case is or is not appropriate for class certification. And
if there were a class appropriate for class certification, you concede that that could resolve the question quickly?
Yes, absolutely.
You concede it could resolve the question quickly through precedent?
Yes, absolutely. It could do so. I mean, we obviously dispute the...
So just on that point...
And if the court... Sorry to interrupt. Go ahead, please. All right, I got a quick one.
Well, I'm just going to say just on that point. So, let's say that we're an individual person even. Let's say it wasn't a class. And goes up and gets a ruling from the Second Circuit that the EO is illegal. Does the government commit to not applying its EO in the entire Second Circuit? Or does it say, no, we can continue to apply the rule as to everybody else in the Second Circuit?
I can't say as to this individual case. Generally, our practice is to respect circuit precedent within the circuit, but there are exceptions to that.
Yes, that is generally your practice, and I'm asking whether it would be your practice in this case.
I can't answer because it would depend on what the lower court decision said. So there are circumstances, as I was suggesting, where we think that we want to continue to litigate that in other district courts in the same circuit as well.
Yeah, so that means it's not even the normal time it takes for everything to get up, through the circuit courts and to the Supreme Court. Because even in those circuits that say that the EO is illegal, you're going to be saying, no, we only commit to saying it's illegal to this one guy.
Before it was then over to Trump-appointed Supreme Court Justice Neil Gorsuch, who drew laughter with a well-timed quip after Liberal Justice Elena Kagan spent several minutes basically torpedoing Trump's Solicitor General John Sauer during oral arguments in a landmark citizenship case.
If you win this challenge and say there is no nationwide injunction and it all has to be through individual cases, then I can't see how an individual who is not, being treated equivalently to the individual who brought the case would have any ability to bring the substantive question to us.
They would bring a lawsuit in the federal district courts against the government for an injunction protecting them. And if the government wasn't respecting, on the hypothetical circuit precedent,
then they win. And again, you need somebody to lose, but nobody's going to lose in this case. It's just you're going to have individual by individual by individual, and all of those individuals are going to win. And the ones who can't afford to go to court, they're the ones who are going to lose.
The tools that are provided to address hypotheticals like this, again, I
This is not a
disagree,
hypothetical. This is happening out there, right? Every court has ruled against you.
We've only had snap judgments on the merits. Obviously, we're fully briefing the merits in the courts of appeals, and our arguments are compelling. More fundamentally, in response to the question,
I'm suggesting to you, like the real brunt of my question is, in a case like this, the government has no incentive to bring this case to the Supreme Court because it's not really losing anything. It's losing a lot of individual cases which still allow it to enforce its EO against the vast majority of people to whom it applies.
And again, Rule 23 provides an avenue to address those very concerns.
Thank you.
Justice Gorsuch?
Well, Justice Kagan asked my questions better than I could have.
Several minutes later, Kagan grilled Sawyer from a different angle, asking what's to prevent the government from taking individual losses in lower courts and never bringing the issue before the Supreme Court. The tense interaction occurred during oral arguments regarding the legality of nationwide injunctions by federal judges. And the Supreme Court is weighing this issue up because the Trump administration has contested that a district judge should not be able to single-handedly stop Trump from enacting an executive order that ends birthright citizenship in America. Trump's lawyers have argued that a judge should not wield more power than the president, especially one as authoritarian as this one. Now, if the Trump administration gets nationwide injunctions overturned, it would mean that the parents of babies born without citizenship would each have to go to court individually to challenge the decision.
On the day after it goes into effect, this is just a very practical question how this is going to work. What do hospitals do with a newborn? What do states do with a newborn?
I don't think they do anything different. What the executive order says in Section 2 is that federal officials do not accept documents that have the wrong designation of citizenship from people who are subject to the executive order.
How are they going to know that?
The states can continue to, the federal officials will have to figure that out.
How?
So you could imagine a number of ways that the federal officials could.
Such as
they could require a showing of, documentation showing legal presence in the country. For a temporary visitor, for example, they could see whether they're on a B-1 visa, which would exclude kind of the birthright citizenship in that country.
for all the newborns? Is that how that's going to work?
Again, we don't know.
Something that the MAGA contingent was sincerely hoping would be met with little pushback from the conservative majority Supreme Court, but were sorely mistaken. I know, imagine someone prioritizing their duty to uphold the Constitution of the United States over serving an autocrat that demands obedience. The shock, right?
How about you're not willing to commit to abiding by the Second Circuit's precedent in my... Suppose that there's a single person who brings a suit, and it gets all the way up to us after 3 or 4 or 5 years. And we say, we really do agree with those 4 precedents that Justice Sotomayor started with, and your EO is illegal. Is that only going to bind the one guy who brought this suit?
No, that would be a nationwide precedent that the government would respect.
So finally, once it gets to us after 4 years, you're going to respect that?
Yes, and in addition, we may well respect circuit-wide precedent. The Second Circuit, it just is...
And for 4 years, there are going to be like an untold number of people who, according to all the law that this court has ever made, ought to be citizens who are not being treated as such.
Well, the response from the Trump-appointed judges is bound to spark quite the reaction from the commander-in-chief himself, once, of course, he returns from his Middle East tour, where he can be seen saluting Saudi military officials while heaping praise on the country he once reprimanded as a state sponsor of terror.
The nation of Qatar, unfortunately, has historically been a funder of terrorism at a very high level. And in the wake of that conference, nations came together and spoke to me about confronting Qatar over its behavior. So we had a decision to make. Do we take the easy road, or do we finally take a hard but necessary action? We have to stop the funding of terrorism. I decided, along with Secretary of State Rex Tillerson, our great generals and military people, the time had come to call on Qatar to end its funding. They have to end that funding.
Oh, how things change when a Middle East Mar-a-Lago is on the table.
Love this video? Continue the conversation by following us on Instagram @MeidasTouch and help us blow past 1 million followers.